With respect to the topics that I have listed for the chapter on real and personal property, you just need to know the definition for many of the items that I have listed. However, there are some topics that need a little more explanation, and I think it would be helpful if I draw your attention to some of the items that I have on that list. For starters, the first item, the distinction between real property, fixtures, and personal property. You need to realize that, for example, when you buy a house, you're buying the real property. You're buying the land and you're buying the structure that is permanently affixed to that property. That's real property. Then you've got personal property. This would be things that are movable. Everything else, anything that's not permanently affixed, generally would be deemed to be personal property. So if I've got maybe a little 110 portable air conditioner unit plugged into the wall, and it's in the window, typically those are considered to be easily movable and personal property. What comes into question sometimes are those things that were once personal property, but they have now been affixed, attached to the real estate in such a way that those items that were once personal property may, because of the way they're attached, may now become a part of the realty. Those items typically are called fixtures. So again, those are items that were once personal property that have now been so attached to that real property that legally it is viewed as part of the real property. And so then those items that are fixtures, title to those pass to the buyer when the real estate is sold. And anything that is deemed to be personal property, title would not pass to the buyer of the real estate unless the sales contract specifically stipulates that those items of personal property go with the sale. For example, window coverings, those are easily removable. You can take down curtains and easily use them in just about any place in another house. So if you're buying the real estate, if you're buying the house, and you want to purchase the window coverings, draperies, things of that nature, excuse me, you want to be sure and list in the sales contract, in that purchase agreement, that along with the purchase of this home, that these certain items that are personal property, they will be a part of that sales agreement. The next item on the list, and I'm just going down the checklist that I've provided for the class, the types of deeds. Just be generally familiar with each of the types. As I recall, you've got 3 types in the book. The quitclaim deed, which is a deed that gives the purchaser just whatever rights the seller may have. It doesn't make any warranties, no guarantees, no promises, other than I, the seller, am selling to you whatever rights I may have in this real estate. Then you've got the warranty deed, which gives good title, essentially says that there are no liens on this property except whatever liens might be specifically addressed in the title. And then third, the special warranty deed, which essentially just says that during the time that I, the seller, the grantor, during the time that I have owned this property, there were no encumbrances. I don't know what may have transpired prior to my owning the property, but during the time that I have owned it, there have been no liens, no encumbrances of any sort during my time of ownership. Next on the list, and again, I'm not addressing every item on the list because some are easily explained in the chapter and they're fairly straightforward, simple concepts. But the forms of ownership, something that people tend to get mixed up on sometimes. You've got the joint tenancy, which is typically how husbands and wives own property. Essentially what that says, if you've got a joint tenancy, is that if either spouse dies, whatever ownership rights that deceased person has, they transfer to the other spouse. And where a tenancy in common says that if either spouse, and it doesn't have to be husband and wife, it could be any two parties, but if it's a tenancy in common, what happens is if one of the parties dies, the property simply goes to their heirs, as opposed to the rights of ownership being transferred to the other person. The next item that's worth addressing, and if I recall correctly, in this edition of the text, it's not addressed in there, constructive eviction. It's just something that is worth knowing about. Essentially, it's when living conditions get so bad in a person's residence that they're forced to move out. Typically, it's going to be something that you'll be dealing with, when you're renting an apartment. And the conditions get so bad that no reasonable person could be expected to endure those conditions, and you're forced to move out. You have been evicted. It's a constructive eviction. The law creates what amounts to an eviction. So that's what a constructive eviction is. A lien is simply a legal claim against property. It's a legal claim used to secure that loan. Trespass to land. In fact, I've got a fairly detailed bit of information pertaining to some of the remaining topics. For example, trespass to land. You've got an act, intent, and causation. We're looking at a tort here. It's a tort against one's property interests. And you need to know exactly what might constitute a trespass. The defendant doesn't necessarily have to enter onto that particular piece of property. You could throw something onto the property. You could, maybe at one time you had permission to have something there. Maybe even you had permission to be there at one time, but once that permission has expired and you remain there, or maybe you leave a boat parked in someone's yard, they gave you permission to leave it there for a week. 6 months later, it's still there. Technically, one could argue that a trespass to land has occurred. So it doesn't necessarily have to be where a person, where the defendant has actually stepped onto that property. That certainly could be a trespass, but a trespass can be much more than that. And as a general rule, mistake is no defense. So just because I thought that I owned this property and it turns out that I don't, if I have committed a trespass with respect to this land, even though I made a mistake, even though it was a reasonable mistake, technically still a trespass to land has occurred. So as a general rule, mistake is no defense. And it's worth noting, just like in practically all of these chapters where they deal with matters of state law, and certainly property law is one that primarily is state law, and it can vary greatly from one state to another. You do need to realize that the laws can vary from one state to another. It's something that I like to remind people that all we're looking at here, all that this text has and all that I'm trying to share with you are just general rules of law. We're not getting into all the exceptions to the rule, and sometimes there are exceptions to the exception. We're just looking at general rules that normally are applicable in states throughout the nation. The next item on the list that's worth addressing would be trespass to personal property versus a conversion. It might help to think of a conversion as just being a more severe set of circumstances versus a trespass to personal property. For example, in a trespass to personal property, normally there would be slight damage to one's property, where if there's a conversion, normally there would be severe damage, great damage, where the property may even be practically destroyed. A trespass to personal property can also occur where there's been some interference with your possessory rights, some interference with your right to possess the property. For example, maybe withholding the plaintiff's property, where a conversion would be some great interference. Maybe if somebody had permission to borrow something for a week and they kept it an extra couple of days, technically you could argue that a trespass to personal property has occurred. But if they had the permission to borrow this property for a week and then 7-8 months later they still haven't returned it, you could argue that there would be a great interference with one's right of possession, and therefore a conversion has occurred. The damages for a trespass normally are limited to actual damages. In other words, you would get an estimate on the amount of damages that had occurred, and that would be your amount of recovery. And certainly there could be some exceptions. This is just the general rule on how damages are assessed. And then for a conversion where there's been extreme damage, maybe again total destruction, what the courts do is just allow the plaintiff to recover fair market value. Essentially what the courts are doing, they're just forcing a sale on the guilty party here, and they're just making the defendant pay for the item that was damaged. Next on the list, a bailment. It's worth noting that you need to know what a bailment is. It's surprising how many times we get involved in situations that constitute a bailment and we don't realize it. Notice the definition. I've got that on the handout for you. Simply, where an owner of property, that person who owns the property, is the bailor, and the bailor gives up two things. They give up possession and control of their property to another person, and the one to whom they relinquish possession and control, that person is the bailee. So think about different situations where you might simply loan something to a friend. Technically, a bailment has been created. They have it, you don't have possession of it, they're in control of it, so a bailment has been created. It could be something as simple as valet parking. You drive up to a restaurant, someone comes out, takes your keys, drives off with your car, and parks it, hopefully safely. And again, possession, they have it. Control, they have the keys, they have control of the vehicle. So again, a bailment has been created. And as a general rule, a bailee is going to be responsible for any damages caused by their negligence. In other words, if their carelessness has caused your car to be damaged, as a general rule, they can't remove themselves totally from liability due to their own negligence. Gifts. You need to be aware of the fact that there are several types of gifts. I have three outlined for you. You have the gift inter vivos. This is just the typical ordinary gift where somebody has the intent to donate it. They have the intent to transfer ownership to another person. Typically, there is delivery. Quite often, delivery can be where they don't actually put the item in your hands or, hand it to you. They symbolically deliver it to you, like maybe they put the car keys in your hand. So you've got donative intent, in other words, the intent to make a donation, the intent to make a transfer of ownership. Delivery. Third, you have acceptance. Typically, the acceptance is presumed, and then the second type of gift that I have listed for you here, the gift causa mortis. That's a gift made in contemplation of one's death. You've got those same three elements for a gift inter vivos, but with a gift causa mortis, the person believes that they're about to die from some particular cause. And then a fifth element, and this is the one that can cause some interesting court cases. The next element is there must be death, but not just death. It's death as anticipated. The person must die from the particular cause that made them make the gift in the first place. And the third type of gift is a gift made in a will. That's the testamentary gift. Next, I have addressed the differences between lost, mislaid, and abandoned property. And this is just a matter of determining the nature of the property that's been found. Is it actually lost, or did the person place it there? They just can't remember where they put it. If that's the case, then it's mislaid property. And then the order of priority, depending on the nature of the parties who are finding it. First, if it's lost property, you've got the true owner. The true owner generally is always going to have first rights to the property. And then if it's lost, the finder has priority over the landowner. If it's mislaid property, in other words, they knew that they put it in this particular location. They knew they left it on my property. They just can't find it. They don't know where they put it. It's been mislaid. If that's the case, then the landowner has priority over the finder. And the last item that's worth touching upon is the liability of landowners to third parties, to individuals that might come onto their property, typically referred to as premises liability. As a general rule, a landowner has a duty to keep their property reasonably safe, and the key, more often than not, is did the property owner know, or should he have known, of this particular danger that might harm someone. This issue comes up often. For example, you're staying at a hotel that's in a high crime area. There are no notices on the doors. There are no notices given to the guests when they check in. And you walk outside to take your dog for a walk at 3 a.m, which is probably not a real good idea. I don't care how safe you think the area is. But if you were to maybe walk out to your car to get something out of the car at 1 a.m, and you're robbed, and the hotel did not warn you that this is a high crime area, then it's possible under some circumstances for the hotel to be held liable for creating this situation where they did not warn you, and they could be held liable for the harm that comes to you as a result of their failing to give you a proper warning. And that should take care of most of the items. Like I said, there are some items on your checklist that are just a matter of reading the chapter and at least knowing the definition of those items. And then these other topics that I've addressed in a little more detail, I would expect you to be more familiar with those particular topics, since I did provide you with more information.